a WikiVidi Documentaries production. Don't forget to like and subscribe. Enjoy. Assault weapons legislation in the United States. Assault weapons legislation in the United States refers to bills and laws that define and restrict or make illegal the manufacture, transfer, and possession of assault weapons. How these firearms are defined and regulated varies from jurisdiction to jurisdiction. In general, there is no clear definition of an assault weapon. Nonetheless, assault weapons are often considered to be semi-automatic firearms with a large magazine, as first defined in a 1994 federal assault weapons ban. The federal assault weapons ban enacted in 1994 expired in 2004. Attempts to renew this ban have failed, as have attempts to pass a new ban, such as the assault weapons ban of 2013. 7 U.S. states have assault weapons bans, 3 were enacted before the 1994 federal ban and 4 more passed before the federal ban expired. The majority of states, 43, have no assault weapons ban, although 2, Minnesota and Virginia, have training and background check requirements for purchasers of assault weapons that are more stringent than those for ordinary firearms. While there are no statewide assault weapon bans in Colorado and Illinois, local bans exist in certain cities or counties in each of these states. The 1994 federal and 1989 state ban in California were prompted by the 1989 Cleveland elementary school shooting in Stockton, California. Existing and proposed weapon bans come under renewed interest in the wake of mass shootings, most recently after the December 2012 Sandy Hook Elementary School shooting in Newtown, Connecticut. In addition to state bans, Washington, D.C., and some U.S. counties and municipalities have assault weapons laws. Expired assault weapons ban of 1994. In January 1989, 34 children and a teacher were shot in Stockton, California, using a semi-automatic replica of an AK-47 assault rifle. 5 children died. President George H.W. Bush banned the import of semi-automatic rifles in March 1989, and made the ban permanent in July. The assault weapons ban tried to address public concern about mass shootings while limiting the impact on recreational firearms use. In November 1993, the ban passed the United States Senate, although its author, Dianne Feinstein, DCA, and other advocates said that it was a weakened version of the original proposal. In January 1994, Josh Sugarman, executive director of the Violence Policy Center, said handguns and assault weapons should be banned. In May of that year, former Presidents Gerald Ford, Jimmy Carter, and Ronald Reagan wrote to the United States House of Representatives in support of banning semi-automatic assault guns. They cited a 1993 CNN/USA Today/Gallup poll that found 77% of Americans supported a ban on the manufacture, sale, and possession of such weapons. Representative Jack Brooks, DTX, then chair of the House Judiciary Committee, tried to remove the ban from the crime bill, but failed. The Public Safety and Recreational Firearms Use Protection Act, commonly called the Federal Assault Weapons Ban, was enacted in September 1994. The ban, including a ban on high-capacity magazines, became defunct in September 2004 per a 10-year sunset provision. Proposed assault weapons ban of 2015. The proposed Bill H.R.4269, the assault weapons ban of 2015, was introduced on December 16, 2015 to the 114th United States Congress, sponsored by Representative David N. Cicilline of Rhode Island along with 123 original co-sponsors. It currently has 149 co-sponsors. This legislation states that its purpose is to regulate assault weapons, to ensure that the right to keep and bear arms is not unlimited, and, for other purposes. The proposed legislation targets various firearm accessories, including the barrel shroud, pistol grip, and certain types of firearm stocks such as telescoping or collapsing stocks. Also included are lists of various classes and models of firearms, including semi-automatic firearms, modern sporting rifles, assault weapons, semi-automatic pistols, semi-automatic shotguns, and others, some of which have already been banned or restricted under existing legislation including grenade launchers, The legislation also prescribes high-capacity magazines. State assault weapon bans. 3 U.S. states passed assault weapons bans before Congress passed the federal assault weapons ban of 1994, California in 1989, New Jersey in 1990, and Connecticut in 1993. 4 others passed assault weapons bans before AWB 1994 expired in 2004, Hawaii, Maryland, Massachusetts and New York. 1989. In May 1989, California became the first state in the U.S. to pass an assault weapons ban, after the January 1989 Cleveland Elementary School shooting in Stockton. The Roberti Rules Assault Weapons Control Act of 1989, or ORCA, banned semi-automatic firearms that it classified as assault weapons, over 50 specific brands and models of rifles, pistols, and shotguns. It also banned magazines that it classified as large capacity. Guns and magazines legally owned at the time the law was passed were grandfathered in if registered with the California Department of Justice. 1999. In March 1999, State Senator Don Perata introduced Senate Bill 23. The bill had 3 provisions: to make illegal the manufacture, importation, sale or offer, or to give all and any large-capacity magazine as defined as having the capacity to accept more than 10 rounds. The addition of a generic definition list to the existing Roberti Rules legislation, and the exemption to allow on- and off-duty and retired peace officers the use of assault weapons. They are defined in Penal Code Section 12276.1 and Section 30515. The bill was passed and went into effect on January 1, 2000. Connecticut. In June 1993, Connecticut became the 3rd U.S. state, after California and New Jersey, to pass an assault weapons ban. In April 2013, 4 months after the Sandy Hook Elementary School shooting, the Connecticut General Assembly passed new restrictions to the state's existing assault weapons ban. The law was challenged, but a federal judge upheld it and ruled it constitutional. Gun owners said they would appeal. Connecticut prohibits any person from possessing an assault weapon unless the weapon was possessed prior to July 1, 1994, and the possessor. Connecticut defines an assault weapon as. Connecticut also bans listed makes and models of semi-automatic firearms and copies of those firearms. Grandfather clauses and other exceptions apply, depending. Hawaii. Hawaiian law bans the manufacture, possession, sale or other transfer of what it defines as assault pistols. Hawaii defines an assault pistol as a semi-automatic handgun that accepts a detachable magazine and that has 2 or more of. In tandem with the assault pistol ban is a law that bans the manufacture, possession, sale or other transfer of detachable ammunition magazines with capacities greater than 10 rounds that are capable of use with a pistol. Maryland. Maryland law prohibits the possession, sale, transfer, purchase, receipt, or transportation into the state of assault weapons defined as assault pistols and assault long guns. Maryland's definition of an assault long gun includes a list of 45 specific firearms or their copies, with certain variations. Maryland's definition of an assault pistol includes a list of 15 specific firearms or their copies, with certain variations. Maryland also defines an assault weapon, copycat weapon, as, in tandem with the assault weapons ban is a law that bans the manufacture, possession, sale or other transfer of detachable magazines with capacities greater than 20 rounds. The United States Supreme Court refused to hear a challenge to the Maryland ban in November 2017. The U.S. Court of Appeals for the Fourth Circuit in Richmond had upheld the ban, stating that assault weapons and large-capacity magazines are not protected by the Second Amendment. Attorneys General in 21 states and the NRA had asked the Supreme Court to hear the case. Massachusetts. Massachusetts law bans the sale, transfer, or possession of assault weapons not otherwise lawfully possessed on September 13, 1994. Massachusetts defines assault weapon by the definition of semi-automatic assault weapon in the federal assault weapons ban of 1994. That definition included, in tandem with the assault weapons ban, as a law that bans the sale, transfer, or possession of a large-capacity feeding device unless such device was lawfully possessed on September 13, 1994. The definition of large-capacity feeding device included a fixed or detachable magazine, box, drum, feed strip or similar device capable of accepting, or that can be readily converted to accept, more than 10 rounds of ammunition or more than 5 shotgun shells, or a large-capacity ammunition feeding device as defined in the Federal Assault Weapons Ban of 1994. New Jersey. In May 1990, New Jersey became the second state in the U.S. to pass an assault weapons ban, after California. At the time, it was the toughest assault weapons ban in the nation. AR-15 semi-automatic rifles are illegal in New Jersey, and owning and publicly carrying other guns require separate licensing processes. Although it is commonly referred to as an assault weapons ban, New Jersey's law actually uses the term assault firearm to define banned and regulated guns. Some New Jersey gun advocates have called its laws draconian. Attorney Evan Knappen, author of several books on New Jersey gun laws, says the term is misapplied and carries with it a pejorative meaning. Illinois. The law that set up Illinois' concealed carry system in 2013 also established state preemption for certain areas of gun law, including restrictions on assault weapons. Laws passed before July 20, 2013 are grandfathered in, and a number of local governments in the Chicago area have laws that either prohibit or regulate the possession of firearms that they define as assault weapons. These include the City of Chicago and Cook County. On December 7, 2015, the Supreme Court of the United States refused to grant a writ of certiorari to take up a challenge brought against a decision by the U.S. Court of Appeals for the Seventh Circuit which had upheld a local law banning assault weapons and large-capacity magazines in the Chicago suburb of Highland Park, Illinois. In refusing to hear the case, the Supreme Court allowed the ruling to stand and the ban to remain in place. Indiana. In March 1989, the Northwest Indiana cities of Gary and East Chicago City Councils passed ordinances prohibiting both sale and possession of assault weapons. Gary City Councilman Vernon G. Smith sponsored the ordinance making it a crime to possess or sell assault-type weapons. Both of these ordinances were invalidated under statewide preemption legislation enacted by the Indiana General Assembly and signed into law by Governor Mitch Daniels in 2011. Brought to you by WikiVidi Documentaries. Would you like to know more?